Thank you, Madam Chair. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read you the preamble this morning. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comments on a particular matter. Would you like me to call the roll, Madam Chair?
Yes, please.
Thank you. Mr. Donovan.
Here.
Ms. Barnes. We do not have Alana Faith this morning, and Ms. Britt.
Yes.
Madam Chair, we have a quorum.
Wonderful. Let's proceed. I couldn't see if, I think the Councilman Mooney is the first councilman to sign in today. Is that correct, Maurice?
That's what I saw, yes.
Okay. We can go to his case, and without Alana here, I'll read and and then Tim, you can still swear in. So
hold on a second. We are going to the second case.
Yes.
There we go.
Thank you. County number 21-116 at 3152 West 95th Street. Urbans Legend LLC owner proposes to build a parking lot in a B1 two-family residential district. The owner appeals from relief from the strict application of the following sections of the Cleveland Codified Ordinances as listed in the agenda and the public record. Go ahead, Mr. Donovan.
Well, everyone, for this case, kindly raise your right hand. I'm going to read a statement. What I'm looking is a response, as I do, with your address. Here we go. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Brian Mooney, Ward 11.
Thank you. Next.
I do. Michael Madonia.
Your address?
3152 West 95th Street.
Okay. Anyone else? Hearing none, we move to history.
Thank you, Mr. Donovan. For this address, I found that there's been no change in the zoning since 1929. There are no variances in the historic record or currently pending otherwise. And I found the most pertinent information is that in our Acela system in 2019, a permit was issued to demolish a two-story frame single-family dwelling. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. The appellant is requesting area variances from the landscaping requirements of the zoning code, as well as permission to construct a parking lot in a residential district. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, that granting variance will not be contrary to the purpose and intent of the zoning code. Subsection 34913C provides that the board may permit temporarily or permanently the use of land in a residential district for a parking lot when the best interest of the community will be served, and provided that the lot is to be used only for the parking of passenger automobiles of employees, customers, or guests of the person or firm controlling and operating the lot, who shall be responsible for its maintenance. No charges to be made for parking on the lot. The lot is not to be used for sales, repair work, or servicing of any kind. Entrance to and exit from the lot are to be located so as to do the least harm to the residence district. No advertising sign or material is to be located on the lot. All parking is to be kept back of the setback building line by barrier unless specifically otherwise authorized by the board. The parking lot and portion of the driveway back of the building line are to be adequately screened from the street and from adjoining properties in the residence district by a hedge, sightly fence, or wall, not less than 4 feet 6 inches tall and not more than 5 feet high, located back of the setback building line. All lighting is to be arranged so there'll be no glare that is annoying to the occupants of adjoining property in a residence district, and the surface of the parking lot is to be smoothly grade, hard surfaced, and adequately drained. The building permit number under which the lot is to be established is to be posted, and the board may impose such other and further conditions as it may deem necessary to reduce the adverse effect of the proximity of a parking lot on the character, development, and maintenance of the residence district in which the parking lot is to be located.
Madam Chair, I think we should leave some instruction, given the fact that we only have 3 board members, and to have any resolution pass, it needs a unanimous vote. So therefore, if any of the appellants want to ask for a postponement, they should do so ahead of our testimony and the hearing commencing.
Thank you, Mr. Decker. We have to do that. Thank you. Okay, Maurice, can you give a quick summary, please?
Right. This is basically variances for putting a parking lot in a residential district, and we are mostly focused on the landscaping and screening of the parking lot in the neighborhood. We are also, and it also requires a lot consolidation.
Thank you. I have Mr. Madonia. Is this your case?
Yes, it is.
Okay, go ahead.
So all the documents have been submitted that Maurice mentioned: landscaping design, fencing design, and we have submitted a lot consolidation plan, my engineering team, with the appropriate parties. So if there are any questions that I could answer to clarify, I'd be happy to do so.
Could you just go through the list of variances that we have here so we can be clear on how you're addressing them, please?
Yeah, definitely. So first one I'm looking at here, which states that a landscaping plan is required. We have submitted a plan for this. There will be 2 mulch beds on the side of the parking lot facing West 95th. These mulch beds are planned to have perennials on both sides of the mulch bed, both sides of the parking lot entrance, excuse me. There will also be a fence surrounding the entirety of the lot. I'm not sure if you have any of these graphics, maybe further in the presentation, but there will be a privacy fence on the back and building side, apartment building side, the north side of the lot, and a lower fence on the West 95th side, similar to the Weston Manor property directly across the street. The parking lot will really mirror that lot exactly. Let's see what else we got here.
Madam Chair, I can say that I have not seen any of the documents that he's talking about.
None were submitted for the presentation?
I don't have any. Did you submit anything to Liz Kukla?
Let's see.
Liz?
I sent emails to mrulins@citycleveland.ohio.us. I'm assuming that's you, Maurice, as
That's
well as
me.
Tupla. And I have
when
been
did
emailing Brian Mooney and Adam Davenport as well. And the emails
yeah
were
when did
sent
you
to
send those?
emails were sent to Cassandra as well earlier this week.
You mean last week, right? Yeah, I don't see them. Let me check.
Ms. Kukla, did you receive anything?
Sorry, I was actually looking right now. I don't remember receiving it. But I'm double checking also.
Mr. Madonia, do you have those handy right now?
I can if it's possible to screen share. I'm looking for a feature with that.
No, we have that disabled.
Yeah, I don't think that's allowed.
Hold on a minute. Let me see what I have. I have something, but it doesn't have any details about landscaping. It just has two bubbles drawn around it.
Yeah, that was the first iteration.
I have these
I don't have
documents.
anything
handy.
after that.
I found them, Maurice. They were sent on Wednesday.
Okay, hold on a second.
I'm sending them again right now.
While we're waiting, what is the parking spaces to be used for?
The tenants of the apartment building just north of the lot. They're currently parking on the street, and we've had a lot of, unfortunately, complaints from the tenants of their cars getting broken into. So the aim is to provide a more secure location for them to park their vehicles.
Okay.
I believe that's the building over there on the right.
It is, yeah.
Did you send that, Liz?
Sorry. Yes.
And while we're waiting on that, I'm not sure, Maurice, are you representing or do we have the planner here?
I believe Adam Davenport is here.
Adam, you weren't sworn in, but, so Tim, can you swear him in right quick?
Okay, anyone besides Adam as well, kindly raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, anyone else out there?
I do.
Okay,
Who just said that?
I'm Asia Browder. I'm waiting on my meeting.
Oh, we'll swear you in for your meeting.
Oh yeah.
Oh, okay. Sorry.
No problem.
We're fine.
Adam?
Yeah. Thank you. So normally I don't think we would be in support of the general concept, but Henley Court behind this building has been vacated, and it was vacated a while ago, and it might have something to do with. I don't know if there were. I joined late. I was having a couple issues logging on. It seemed like my computer required some updates, so I wasn't sure if photos of the property across the street were shown. There's a building owned by Eden that has a very similar parking lot right behind the building, where the court, Henley Court, probably ran through back in the day. So maybe at that time of that project, the court was vacated through this section of the neighborhood, but it's no longer an alleyway. And then a while ago, it seems like a house was demoed there, or foreclosed upon and demoed, and has been privately held up until Michael and his LLC acquired it. So that would sit vacant through the foreclosure process for some time in the future if he had not kind of been proactive and sought this out. I think it's important to adhere to the fencing and landscaping requirements required by our code. And so I've talked to Michael about putting landscaping in the front of the area along 95th, and then adhering to the fence code, 6-foot privacy fence on the southern border, and then coming down to 4-foot or 3-foot in the front. But happy to address any other questions the board has as well.
Thank you,
Does-
Adam.
Still
does that
nothing from
mean
Liz.
he meets the code?
I think he's meeting the fence code as it currently states, with the plan, and then, there are some, I understand a little bit some of these dimensional requirements, from the parking spaces. Like there was a suggestion that I had to remove the southeasternmost space and put one in the back where it says kind of Henley Court, but that owner of that vehicle would have to then reverse out the entire length of the parking lot. It's not like a back in, back out situation where you can turn around very easily. So whatever, I think the important thing to take into consideration is that southern property neighbor and kind of buffering their front yard with landscaping or fencing. I think is kind of what we want to uphold here.
And does his current plan do that?
Yes, it does.
So that he doesn't need a variance for that component?
Not for the fencing, I don't believe so.
Okay.
I've actually spoken to, I'm not sure if they own the building or just rent the building to the south of the parking lot. And I think they're actually very much looking forward to the installation of the lot, just because there's a lot of, hanging out going on in the lot as of currently.
Madam Chair?
Yes.
So just as a point of clarification, the landscaping would not meet the code, as there are requirements other than, I don't believe that the perennials would meet the zoning code. I believe it has to be a solid row of hedges that are at least 50% opaque. I don't know if Mr. Riccardi is on the call to clarify what the requirements of a frontage strip for a parking lot would be, but I do believe that perennials would not meet the code.
Thank you. Mr. Riccardi on?
This is the last drawing this is the drawing Liz just sent. It has no landscaping details on it.
Mr. Medoniak, did you have a different plan with the landscaping on it?
Yes, I sent probably 15 pages worth of plans over. Unfortunately, I can't screen share. I'm not sure where the email went.
Wait a minute, I see them now.
Got them?
This situation where we're reviewing new plans at the
in real
hearing
time.
itself.
Yeah.
Usually we would say time out, reschedule it, give the time for the city planners and the appellant to work out any differences.
I don't know if that's the case necessarily, or we just didn't have the plans in front of us. So
What everybody's saying.
These are the plans. You can see these, correct?
Yep, those are the full plans with all the sewer details, etc. There should be some other documents where the fence and landscaping is detailed.
Maurice, do we have those?
Yeah, I'm digging them out now. Here we go. Here's another one. He sent me a lot of documents. There's the next one.
Yep, so that's the fencing plan. The solid line indicates the 6-foot privacy fence. Dashed line indicates 3-foot shorter fence. Would likely be a metal black fence, very similar to the property directly across the street.
Okay. Do we have the landscaping?
That's next. Hold on. That's what I have for a landscaping plan.
Okay.
So that's the simple one. There is one with a little bit more detail, just showing the types of perennials that will be placed. Would happy
This one says
to go ahead.
parking lot with landscaping. I don't know. There's parking lot basic one. I showed you that one. Parking lot full plans, boundary survey and site.
We did,
That's
still
what I
didn't hear
have.
from Mr. Riccardi about whether perennials qualify or do they need to be hedges. Mr. Riccardi, are you there?
I am. If you, I'll go back and check the zoning code. You know, get back to you in a few minutes to conduct this review.
Madam Chair, it is number one on the write-up, section 349.08, which states that where 5 or more accessory off-street parking spaces are provided and are located on a lot that is adjacent to a residence district or adjoins a building containing dwelling units, this is just the screening from adjoining lots in a residence district or building. I apologize. I don't see a frontage strip required. Madam Chair, the issue with this also is if you look at number 5 on this adjudication here, section 334.20 states that in order to complete a building and housing review, a revised site plan is required. It should be drawn to scale. It should show parking lot stripings, dimensions of spaces, bumper guards, drainage, slope, sewer connection detail, landscaping detail. We received this on Wednesday. We probably should have routed this to building and housing to determine if there were any other issues. As you can see from this write-up, building and housing did not have everything they needed to complete their review. And I'm not sure that even if we did route this to building and housing after when we received it on Wednesday, if they would have had enough time to turn it around. So postponement may be necessary.
Yeah, I was just thinking that because if building and housing didn't see the new plans, some of these variances might be met already, and there was no need for the write-up. So Mr. Madonia, we're gonna have to give your plans time to make its rounds through building and housing first before it comes back to us. So Liz, do we have a date we can get them on?
Madam Chair, August 23rd is pretty full. However, we could squeeze them on since we've had some testimony already. Unless you wanted to take some more testimony from Councilman Mooney to determine if there's any objections.
Yes.
Squeeze it on, but the next date after that would be August 30th.
Yes, let's hear from the councilman, and then we'll just go on since we got a lot of this out the way today. Councilman.
Thank you, everybody. Thanks for having me. I just want to get on the record. Mr. Bedonia has been fantastic. He purchased this building, and he contacted me and Adam Davenport. We've had so many phone calls and emails since April, and I'm excited about this project and fully in support. His apartment building's on the corner of Lorraine and 95th. This street is notorious. It's where I have 24-hour-a-day prostitution, 24 hours a day, right here on 95th, day and night, that and 94th. And this house that we tore down, before I was on council, I worked for Westtown with Councilman Brady. It was a prostitution house. I can't tell you how many times I went into it to personally chase out the heroin addicts and the prostitutes. And the owner of the house lived in Parma and just wouldn't do work on it. So we were excited to get it torn down, and the neighborhood was, because that unfortunately it wasn't a foreclosure, so that homeowner still owns the property, which presents problems moving forward. So Mr. Madonia's plans were exciting to me because he was going to make his own arrangement to purchase that property as part of this. And the alleyway there had been vacated, and there were issues, with the dumpster and stuff. So there's no parking here. And I recognize that's a problem. So I'm fully in support of this to create parking. And he did comply with having a 6-foot fence and then a 4-foot fence to the property to the south, which is a rental, to provide a barrier. As far as on the street side of 95th, I'm in support of his perennials or whatever. I don't know that you'd want bushes there because it would block view of the parking lot. This is an area where the prostitutes are. I mean, it's day and night. It never stops. And I don't know that we want bushes to block the view. But to me, the more of concern was the southern property, which I believe he's addressed, and maybe you need to look at it. But there is no parking for this building. Madonia is a much better owner. He's done so much work here. He's jumped through so many hoops with me and Adam, working on this on his own volition. And I am strongly in support of this. I just want to get that on the record. I don't know if it's important what type of plants or whether there's a tree or not on 95th, but to me, it's the fencing issue. And this project, he's put a lot of work into, and he's going to consolidate it. And it's just another effort to improve this Lorraine district. So I just wanted to get that on the record in case I can't make the next hearing.
Great. That's why we wanted you to say something now. Great. Thank you, Councilman.
Madam Chair, I just wanted to make the comment that, we do generally support the use of this property as a parking lot. We just need to get the right drawings, to building and housing and get it all done properly and with the proper, screening and everything, and we're good to go. So it's just a matter of the details at this point, I think.
Great. All right. Thank you, Maurice. Thank you, Councilman. Mr. Madonia, we're going to put you back on the calendar for 8/23 because we've had testimony today. And it's just to give your drawings time to move through building and housing. And then we'll bring you back and hear you quickly. So just wanted to let you know that. Do you have any questions before we move on?
No, thank you, everybody. Thank you, Adam. Thank you, Councilman Mooney. Really appreciate it.
Great,
I definitely suggest working with Rick Riccardi and, building and housing and make sure you get all those in and so we can get this approved and moved along.
Will do. Rick, I'll talk to you.
All right. Thank you. Okay, do we have any other council people here?
Yes, Councilman Polensek is, I believe, one of the call-in users. Councilman *6 to unmute.
He would be the only other council person that I see at the moment.
Well, let's hear the case.
If he's here.
If he's
Councilman?
here, that's fine.
He does usually call in *6 to unmute yourself, sir.
Well, then go to the next case.
Okay. We will go to the first one.
Back to the first, okay.
That'll be calendar number 21-112 at 10934 Hampden Ave. They appeal for looks like a nuisance ticket. So Asia Marie Browder, owner, appeals under the authority of section 76-6B of the Charter of the City of Cleveland and section 32902D of Cleveland Codified Ordinances from the decision of the hearing officer dated May 11th, 2021, to uphold the City of Cleveland's Department of Public Works to issue invoice. I'm not going to read all those numbers regarding abating nuisance at the subject property.
All right. Everyone who's going to testify, kindly raise your right hand. I'm going to read a statement. I'm looking for a response of I do with your address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Name, address?
Asia Browder, 10934 Hampden Avenue, Cleveland, Ohio, 44108.
All right.
I do. Natasha Brewster, manager of the protest department.
Thank you. Anyone else?
Ariel Kolk, Department of Assessments and Licenses, City Hall.
All righty. Anyone else? Hearing none, we go to, I guess, legal stand.
Right.
Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed. And I'd just like to state that I read through all the materials that the appellant submitted, and I'm not sure whether the board has jurisdiction over this appeal. And I will state what I see as the issues, and maybe the appellant can address them. The invoices in question were appealed, according to her statement, in 2018, and that was affirmed. And as far as the invoices go, that appeal needed to be taken in 2018. The appellant is, in her statement, she's indicating that the problem is that the invoices, that was paid off and she's still getting billed for it, and that late fees and interest are being charged. If that's the basis of, only basis of her appeal, that is not within the jurisdiction of the city of Cleveland. I mean, we submit these invoices to the county, and what happens after that is up to the county. So I would hope that the appellant could address that issue.
Thank you, Ms. Wagner. I have notes right here because I read through the paperwork myself and was wondering, first of all, that it was from 2018. So why are we getting it now? And then also reading through what you just said, it seemed like they were paid already. And so does that really apply to us? So Ms. Browder, can you clarify what this appeal is about, please?
Yes, I paid off those amounts with the payment plan with the county. The county told me that in order for them to stop charging me taxes and penalties, that they needed to receive a letter from the city of Cleveland acknowledging that it was paid off. Until then, they can't stop charging me unless the city tells them to stop charging me. That's the only way they could charge me, is for the city to tell them to stop charging me. I have appealed this before 2018. I did appeal it with Miss Brewster, but again, I kept being denied. She kept telling me that I did not have sufficient evidence to say I either live there or, you know what I'm saying, what have you.
Wait,
but I
so
also,
I'm sorry. So you did actually make payments on this, and the payments are done, and you're saying you're still being charged. So
yeah.
so Ms. Wagner, I believe this is not the case.
Once again, that's totally within the jurisdiction of the county. The merits of this appeal, when the appellant was arguing she shouldn't have been charged these fees, if that's what she's arguing, that appeal was taken in 2018 and was not appealed to BZA. Everything she's talking about afterwards, as far as whether they've been paid off or late fees, that's all with the county. The board doesn't have, and the city of Cleveland has no jurisdiction to tell the county whether something's paid off or not paid off, whether there's late fees or interest. I mean, it seems like her complaint is with the county, and unfortunately we don't have
it's not
any
with the
ability.
county. I've spoken to Miss, I'm sorry, I don't mean to interrupt you, but Miss Brewster is well aware of what I'm talking about. She's the one who keeps on denying to contact the county and tell them I paid it off, because she says she doesn't see that I paid it off. I've tried. It's like she's taking it personal with me over all these years. She's not being professional with me. I've had several conversations with her as the manager of Parks and Maintenance, and she refuses to give me a letter stating that I paid these things off. She said I had to prove that I paid them off in order for her to give me a letter, and everything that I've sent to her to prove that I paid it off, she's not accepting. So I don't know what her problem is with me, but I think
Ms.
it's
Browder,
personal.
Yeah, Ms. Browder. Okay, these things are outside the realm of the Board of Zoning Appeals today. So
well, I have another letter. I have an invoice from the Department of Finance, Division of Assessments and Licenses, saying that the invoices contained on the official notice have been paid off. So all I want is a letter.
What I'm saying is, this is not the body for you to to argue your case here. You have to go directly to Ms. Brewster and whoever else. If it is in fact that you need to get this letter, you can't come through the BZA body. We don't address those type of things. So, Ms. Wagner, what's the best thing to do here? Just for us to dismiss this case?
Can Natasha Brewster say
First of
something?
all, I would like to, in response to what the appellant just said, it sounds like she's got a letter from the finance department saying it's paid off. So,
Here it is right
well,
here.
then
It's
you need to
credited.
submit that, excuse me, ma'am, you need to submit that to the county. But this is not, I would recommend that the board dismiss this for lack of jurisdiction because this just isn't something the board has the ability to review. As I said, the
It was
merits of
supposed to
the merits
receive a
of the,
letter.
Excuse me,
I'm
Madam-
getting confused because if
Madam
I'm
Chair.
supposed to get a letter from the city to take to the county, how is it not related?
Because this
Madam
is
Chair.
not who, this is not the body that you get that letter from. This is,
Madam Chair.
we're the board. Yes, Ms. Barnes.
Madam Chair, I move that we dismiss this case from the board.
Of course you do. Somebody I'm not paying this, so somebody gonna have to figure it out. I already y'all need to tell Natasha. I don't know who
I
her
have
boss
a-
is, Ms. Leffridge.
Ms.
It's like
Browder.
I'm not getting anywhere with this, and it's proof right here that it's paid off. Y'all gave me a credit saying I don't owe anything. So
Ms.
I don't know
Browder,
who it's
Ms.
supposed to
Browder,
go to.
Ms. Browder, I understand your frustration. However, this is not the proper venue for it. That's what we're telling you. We're
Who
not telling
is?
you that, we're not
Who
telling
is
you that
it?
you're right or wrong. This is just not the proper venue.
Who are the proper people for me to go through then?
They're on here. Ms. Brewster, can you give her, I know you guys have spoken before, but we're about to dismiss
I
this
don't talk
case.
to her anymore. I don't want to talk to her anymore. She's rude and she's not
Madam
getting
Chair, we are
anywhere.
not going to hear this today. Can we please
Yes.
dismiss this case?
So we do have, we have a motion.
the
Can I have a second,
director.
please?
This has been moved up to the director and the commissioner because of the intensity of this case of her keep calling and playing on the phone and me trying to walk her through of what was paid, and by her not making the full payment that was supposed to be paid to the county, it occurs interest and penalty fees, just like you're paying the taxes. If you don't make the first payment in full, by the time the second payment is due, interest and penalty fees is added. And I tried to walk her through of all of this. And the information that I submitted to you all is when she actually lived there. These charges is not when she lived there. This is when she abandoned the property, when it was boarded up and everything, not when she actually stayed at this property. But she don't want to walk through with me. She called me when she was at the county, and she said that she was on a payment plan. I told her that the county has to pay the city of Cleveland. And that's what she had to go through, the county, but she didn't make the full payments, which cause interest and penalty fees when it is not paid in full.
Okay. Okay. Ms. Barnes made a motion to dismiss. Can I have a second, please?
Sorry, second.
Thank you. Ms. Kukla, call the roll.
Mr. Donovan,
Yes.
Ms. Barnes,
Yes.
Ms. Britt.
Yes.
Calendar 21-112 is dismissed due to lack of jurisdiction. We will ratify this next week and send you a letter.
Thank you.
Right. Moving on to calendar number 21-119 at 1803 West 48th Street. David and Christine Filmer, owners, propose to erect a 33 by 95.5 one-story frame single-family residence with attached garage in the B1 two-family residential district. The owner appeals from the leave from the strict application of the following sections of the Cleveland Codified Ordinances as listed in the agenda and the public record, which it seems to be one.
Anyone who's going to give testimony for this case, kindly raise your right hand. Again, I will basically present a statement. I'm looking for a response of I do with your name and address. Here we go. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Michael Horton, 812 Huron Road East.
Thank you. Next. Last call. On to history.
Thank you, Mr. Donovan. There's been no change in the zoning since 1929. There are no variances on file for this address. And I did find in the Building and Housing's Records Administration Office that in 1985, a permit was issued to demolish a structure on the site. Madam Chair, I did receive one letter this morning of concern. Would you like me to read that now, or would you like to take other testimony?
Yeah, we'll move through the case a little bit first. Thanks.
Okay, thank you.
Okay, legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance in the rear yard requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you. Maurice, I think this is very simple, but go ahead, quick summary.
Yeah, it's pretty simple. It's just a very small rear yard variance. I will say that this house has not been to HDRS yet, and I discussed it with Matt Moss, who's the neighborhood planner for the area, and he's okay with this moving forward without having gone to HDRS yet. But of course, there always is the possibility that if they request some changes, that can change a variance situation. Just, throwing that out there.
Great, thank you. Okay, we got Mr. Horton here for the owners.
Yes. Thank you, Madam Chair, members of the board. Michael Horton with Horton Harper Architects here on behalf of David and Christine Filmer. What you see here is the site plan for their eventual single-family house. They currently live in the neighborhood, and we are working with them to design their new home on West 48th Street. I'd say the floor plan is fairly straightforward. We do have West 48th Street Place, which is an alley that allows for rear access to the lot. We took advantage of that to eliminate any curb cuts or add any curb cuts on the street. The homeowners are they plan to live here for as long as they can, and they're I think in their 60s and 70s. And they wanted a plan that would allow them to age in place and accommodate future wheelchair, have accommodations for a wheelchair and easy access. For that reason, the finished floor of the first floor is fairly low to the ground, which is not consistent with the rest of the street. Some of the porches are a little bit higher, the stoops are higher. And they're also, like most of these homes you can even see in the houses next door, requesting some exterior space or some yard space. So in order to accommodate eventual wheelchair, we had to connect the house. And so we built the house around an internal courtyard. And so we're still allowing to have the garage connected to the home, which is why it is organized the way it is. And that brings the house back further than the rest of the homes on the street, but that's really an effort to just connect the garage to the house, which is not typical of most of the houses on the street. Other than the rear yard variance, it's a single family house. It's fairly unimposing in terms of its presence on the street. Other than the site plan, maybe a front elevation might be would give you on the next slide, I believe it is, will give you an idea of what the house will eventually look like.
Yeah, okay. Yeah, this is a very minor variant, so you don't need to have the full presentation. So thank you. Board, any questions? Okay. And Maurice, you said that Matt Moss is okay with this
Yeah, what,
as far as city
you
planning
approve
goes?
it? Right, you can go ahead and we support the variance and still take the house through HDRS after this.
Great. Since there was no questions, minor variance.
Madam
Board,
Chair?
yes,
Madam-
Liz.
If we can get this letter on record.
Oh, yes, I forgot all about the opposition letter. Yes.
Sorry, and it's more a concern. It's from Faye Harris. Her address is 1810 West 47th Street. She said that her only concern is that the garage should not be built right at the base of the alley. The garage should be built 75 feet or more into the interior of the backyard. The reason is when people back out of their garage onto the alleyways, they always drive into the neighboring fence, which would be directly across from their garage. No, this is probably not a concern with BZA committee, but it is a concern for the rest of us who have to deal with this on a daily basis. I do support the development of a new single-family house, which will be located at this address.
Great, thank you. Board, can I have a motion, please?
Chair, I motion that we approve the variance as stated.
Thank
Second,
you. Can I have a second? Great. Call the roll, Ms. Kukla?
Mr. Donovan,
yes.
Ms. Barnes, Ms. Barnes,
You made the motion to vanish.
can't hear you.
Ms. Barnes, yes.
Thank you. Ms. Britt,
Yes.
calendar 21-119 is granted. It'll be ratified next week and we will send you a letter.
Thank you.
Madam Chair, we need to go on to Mr. or Councilman.
Councilman Polensek, yes.
Can you hear me? Can you hear
Yes,
me?
we can hear you now,
we
Councilman.
can.
Yes, we're gonna read your case now, sir.
Thank you.
Calendar number 21-105 at 14100 Lakeshore Boulevard, Breakwater Tower LLC. Owner applies to erect a business identification wall sign, 384 square feet in area in a C2 multifamily district. The owner appeals for relief from the strict application of the following sections of the Cleveland Codified Ordinances as listed in the agenda and the public record. No testimony was given. The first postponement was made at the request of the board to allow time for updated adjudication to be published.
All right.
Donovan?
Everyone for this case who's about to give testimony, kindly raise your right hand. I'm going to read a statement. I'm looking for a response of I do with your name and address. Here we go. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Mike.
One at a time.
I do, Mike Polensek.
Thank you, Michael. Anyone else?
I do. Stephen Gessis, 67 Alpha Drive, Highland Heights, Ohio, 44143.
Thank you. Anyone else? Last call. Hearing none, on to history.
Thank you, Madam Chair, or sorry, Mr. Donovan. The, just to note that section, number 3, I'm sure Ms. Wagner is going to read this as well, but this is also an administrative appeal from the City Planning Commission denial. So onto history, the property was originally zoned general retail in 1929. In 1990, it was changed to multifamily residential. I didn't find any records in the Records Administration Office, no variances on file. But I did see in 2018, a certificate of occupancy was issued stating that the legal authorized use of the property is 112 dwelling units. And that's all that I have, Madam Chair.
Thank you, Ms. Kukla. The legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the sign requirements of the zoning code and is appealing the decision of the City Planning Commission denying approval of appellant's proposed sign. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. The standard of review to be applied for an appeal on an administrative decision is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed. And once again, the administrative decision in question is the decision of Planning Commission to deny approval of the sign.
Thank you, Ms. Wagner. This seems to be the repeat of the case we had last week. So we have to break it apart and talk about the administrative appeal first. And then we'll go into the signage second. So who is going to be the spokesperson for this case?
Sure, Stephen Gessis. I'm sorry, I'm not familiar with what may have occurred last week.
Yeah, no, that's just for that was for my board. That was really not for you.
Oh, okay, got it.
So you are appealing the city planning decision first, so you should address that first, and then we'll talk about the actual sign characteristics later.
Yes, ma'am. So,
excuse me, just as a point of clarification, in the write-up, does it address this again, review of the decision by city planning or not?
Yes, in number 3, it says City Planning Commission denied and administrative appeal is required.
Because this is what I would consider a 2-for-1.
Yeah.
And I don't think we give 2-for-1.
Well, what happened last time was we had to split it up. So I guess my first question would be, because it says administrative appeal is required. Have you appealed the decision from City Planning Commission already, or do you have to do that?
No, ma'am. We were advised that our next step was to go to zoning.
And you can go to zoning and you can appeal their decision. And then that's a case in and of itself.
Right. Ms. Kukla, what's happening here?
Well, Madam Chair, this is really a conversation that should involve Ms. Wagner as well. This is we're doing it a little different from what we've done previously, in that we've been advised by Ms. Wagner that these two decisions can be intertwined or combined, as we did with the other case on Waterloo last week. So I guess Ms. Wagner can speak more to it as to how this works together, but both decisions are supposed to take place separately. The City Planning Commission is required to approve it separately, but also the zoning code itself says that Planning Commission is required to. So it is unusual. Ms. Wagner, I don't know if you can speak more to it.
Not too much. The Planning Commission denied approval of this sign, and that is being appealed to this board under the arbitrary and unreasonable standard. The appellant also appealed for variances from the sign code to allow the sign. And so even though they involve similar issues, they're two separate appeals. If the board, of course, determined that the Planning Commission decision was unreasonable and reversed it, then you wouldn't have to address the variances. But if the board affirms Planning Commission, then it's going to address the variances.
Correct, but my question to the appellant was, did they officially appeal City Planning Commission's denial? Is that on the record that they officially appealed that?
No, ma'am. As I said, we followed the charted course, and we were advised the charted course was the next step was at zoning. So I'm not familiar with the appeal process required back to planning. If that was the case, we would have certainly completed that element, but we were advised that the next step was and the process was to go to appeal this zoning. So I'm sorry, I'm just not.
Well, both
I'm
issues end
just
up
trying
with
to comply
zoning.
with the map that was provided to us.
You go to zoning to appeal their decision. That is
Yes.
one aspect of it.
Yeah, but my concern is they haven't officially, so the write-up is saying that an appeal is required as if they have not appealed it yet. And the appellant is telling us that they have not appealed it. So how can we hear a case and they have not officially appealed it is my question. Ms. Wagner?
Madam Chair, could I address that question? I think
Yes.
last week when we had a similar circumstance, the board, notwithstanding that the appellants may be confused as to the exact procedures or what they're appealing, we did treat the other case as both an administrative appeal and a request for variances. I think for the sake of continuity, the board decided to do the same for this case, which is why it was continued to be re-advertised. So I think that what the appellant wrote on the appeal may not be as relevant because often the appellants do not know what they're appealing. That's my opinion.
My opinion was that case last week was messy at best. And that was the first time I can remember that we've allowed it. Prior to that, all of our deliberations would take a prioritization that would first and foremost address whether or not city planning's decision was arbitrary, capricious, etc. That decision would then lead the appellant to whether or not there is a course for variances on the project or not.
Correct. And I think we can make that determination today. I just wanted to make sure that the appellant actually asked for an appeal of the administrative decision before we started talking about it. So if that is the case, then we can talk about whether City Planning Commission's appeal was arbitrary, capricious, or not substantiated by the facts. So we'll take part one and review the City Planning's commission's decision. So who has information for us about that decision?
I believe Shannon Leonard, our staff planner, was at the CPC denial. Shannon, did you want to speak on this?
Oh, yeah, Shannon Leonard, City Planning, back from.
Shannon, were you sworn in?
I was not.
Mr. Donovan?
All right, here we go, Shannon. Do you swear that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Name.
All right. Shannon Leonard, City Planning. So this case was a while back. The City Planning Commission Design Review had denied this. This was labeled as an art mural. Obviously, it is the name of the real estate development company that now owns the building. Therefore, it is a business sign. The Design Review had denied this as inappropriate, way out of scale, too large for this specific residential building. The fear is obviously they don't want the entire area to start having these massive signs, especially after the fact, without going through the review process and just popping up on without the permits. And then City Planning further denied that Design Review denial due again out of scale, out of size, not appropriate, did not match the character of the street or the neighborhood. And so in that case, City Planning Commission was not arbitrary and capricious in their denial of the design. They just, simply did not believe that the design matched, and they followed the design review guidelines of the zoning code. And then also they would require massive variances that were not minimal from the current sign code for this property in a residential district.
And so Shannon, oh, sorry, let me ask right quick. So this sign is currently up, and so is this like they were after the fact trying to get permission?
Yes, this sign, this specific property was definitely up long before they went to design review and long before they went to planning commission and as of here now as well.
I'm sorry, go ahead, Mr. Donovan.
I was gonna ask if, given the denial of the current representation, there would still be an opening if the appellant wanted to scale down the size of the identification?
Well, he has
to,
other business identification signs on the property. There's a monument sign that was approved by planning commission and the design review. But the wall sign here, they could potentially have to come back, but they would still probably need a variance because they have other signage already.
Okay.
I'm not sure without having the dimensions of the other signage.
Okay, but it's your testimony that this case was treated as any case of this nature would be treated through those two processes?
Yes, it was through the sign so the applicant had applied as if it was an art mural. Obviously, the Building and Housing Department and City Planning Commission deemed this as a actual business sign because Smartland is the name of the real estate development company that owns this building, that bought this building, and did some remodeling. And while City Planning appreciates the upgrades that were made to this building, this sign is above the size and scale that they felt was appropriate for this building and this neighborhood.
Does the appellant have any response to the question of arbitrary, capricious, unsubstantiated by the facts? Hello?
You're muted.
Yes, I do. Thank you. Yes, so several things. Number one, we did do the installation unaware that there was a procedure in place for it. Hence, we then went and, are going through all the appropriate channels in an effort to get this permitted. We were simply not aware. We have mounds and mounds of communication, both with building and housing and planning and also personal meetings that were conducted in an effort to, get this achieved and get done what needed to be done. Number two is that the name of the company is not the ownership group. The business that owns that tower is 14100 Breakwater LLC. So I just want to make sure that that's clear. Ms. Leonard misspoke on that. In regards to getting a fair communication in the last planning meeting, I would argue strongly against that. Number one, I've been verbally attacked on numerous occasions, unnecessarily. I don't know where it comes from. In the last meeting, other buildings or properties were brought into discussion that are also well maintained, have nothing to do with this property or planning. And then I had been attacked about ownership, equity in the community. And so the one thing that I want to make clear is that being an owner of the property, we have a significant amount of equity within the community. We have improved this property immensely, which both from an operational standpoint, aesthetic standpoint, but also from a community standpoint for the residents there and the residents around us. Constantly, the properties around us that are managed by the City of Cleveland and owned by the City of Cleveland are not cut and maintained. While we strive to be the anchor in the community that seeds the rest of the community to be able to improve. The adjacent property immediately to our left, if you could slide over, is abandoned, has been abandoned for quite some time, is in deplorable condition, failing, specifically right here. That's at the intersection of 140th and Lakeshore. It's an eyesore. We just completed another massive improvement of the rear parking lot, got seal coated, new striping. It has a fence in the back. It has a dog park area for our residents. This is the property immediately at our neighboring adjacent property that's up on the screen. The garages are failing. There's cats. that have inhabited the space, beavers, all sorts of wildlife now that has made it its home. It's unsightly, and you know, we've only had good intentions, and we have risen and to this occasion, and we have done an amazing job at this property, not only for the community around us, but also for the residents there. And you know, now these residents feel proud of where they live. When we purchased it 3 years ago, it was in poor condition. It was underserved, and to paint anything other than, you know, our intent to be a good operator is just wrong. And that's what happened in the planning commission last time. And so it
Okay,
really,
sir,
really
we need,
diverted.
we really want to stick to the sign issue. I understand you probably had to present most of this stuff to planning commission. But we just want to stick to the issue that's before us today is the sign.
Yeah,
So
we're
we
just
can
looking
just
at a
focus
variance on
on,
the sign.
yeah.
We're looking at a variance on the sign. We're here, yes, after the fact. We're not familiar with the process. We're adhering to all the processes. We've met with all of the institutions. This sign does not, there's nobody else around us the idea that somebody else is going to start painting this, there's nobody around us. There's nobody with a building around us that is not only this large, but also is maintained, or there's nobody around us. So to say that this will set a precedence for somebody to do it somewhere else, there's nobody else around us. You know, this was not clearly our intent. We did not expect to even be here. We're seeking a variance on the signage. It's part of the modern appeal of the building. It doesn't deviate from the neighborhood. There's a Tesla or electric car charging station a few parking spots over from where this gentleman is standing next to the S. You know, we have a green initiative here, and part of this green initiative is to be proud of. You know, if we weren't proud of what we were doing here, we wouldn't place a name on there, right? So, you know, we take ownership and pride in what we're doing, and hence we're asking the board for a variance on the sign. We have support from the councilman. He has been at our property numerous times. We visited with him. He's been able to see the transformation firsthand on the ground, what this has now done to the community.
Okay, thank you.
Can we go back
are
to
you-
the original?
Yeah, we're back.
The original thing. I mean, this was supposed to be an art mural?
Our intent that it was, yes, we considered it art, but there's clearly a definition that has been presented to us where this is not considered art. We did it from an art perspective.
Okay, so, but, excuse me, but when city planning, design review, etc., reviewed the request, it was reviewed as an art mural.
No.
And their deliberation then had to be on whether or not to approve that or not. Did that fit into the city of Cleveland, basically criteria to allow for an art mural here? And I don't know. I'm not hearing anything arbitrary or capricious.
Mr. Donovan, this wasn't reviewed as an art mural. This was reviewed as the sign that it is. It was never reviewed under the public art or art mural. It was reviewed by design review and planning commission as a sign, because Smartland is the name of a business. It may not be the specific LLC that owns this property, but it is somewhere intertwined in the applicant's business model. So this was reviewed as a sign, the sign that it is, under the zoning code, as well as under planning commission and design review. And in terms of the design review, the signage, the design review committee, as well as the planning commission, did not believe that this sign was appropriate for this building in terms of scale and design. And under the law, under the rules, under the zoning code, they are permitted to make that decision. So again, this was reviewed as, even though the applicant thought it was an art mural, he was informed on multiple occasions before it went to design review and before it went to planning commission that it was a actual signage. We met with him
Yes,
personally.
we're not arguing that. It's yes, we now are looking for a sign variance. Our initial intent, it was art, but we are seeking a sign variance after we've had a numerous amount of conversations and meetings with the various departments. Yes.
Madam Chair, we
Okay.
have Mr. Riccardi with his hand raised and Sharonda Watley, the neighborhood planner.
Yes, so if either of you have input on what we're looking at first is the actual planning commission ruling and decision, yes, please speak on it.
I just wanted to state that I did just email a few minutes ago the Planning Commission ruling from April of 2019 to Mr. Rulins and Ms. Kukla. So if there's an issue of whether this is, whether city, and it may not be an issue now that Shannon has spoken, but I did include the, their entry to Ms. Kukla and Mr. Rulins. Thanks.
Thank you. Sharonda,
Yes,
were you sworn in?
I was not, so if you all need to swear.
Okay, here we go, Sharonda. I'm looking for I do, and in your case, what agency you represent. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Cleveland City Planning.
Agency?
City Plannings.
All righty.
Thank you. Good morning, everyone. Again, Sharonda Watley from Cleveland City Planning Commission. And so I do want to affirm that this did go through a very robust process. Again, it went to design review. It also went to Planning Commission. We also had multiple conversations with Mr. Guesses about the installation. One thing that I do want to make sure that I note is that we do understand that it already exists, and there was a bit of concern about whether or not it could be removed pending the outcome of this particular hearing. The committee, and I do believe the community, would be open to an actual mural at this location. It is a bit of a tower or a mid-sized tower in the neighborhood. I believe it's about 8 stories. You can correct me if I'm wrong, Mr. Guesses. And so if you really wanted to do something artistic here to really bring attention to your property, we would definitely be supportive of that as well. Thank you.
Thank you.
Would you be open to something different here other than Markland sign?
Yeah, we would consider an alternate mural. You know, obviously there's a cost both in removing or redesigning, but it's not something that we would be against. You know, we want to brighten. Our goal is to brighten the neighborhood. I mean, it's, you know, modernize it, brighten it, make it feel like, you know, it's part of something, and for residents to have quality, you know, a high quality of life. And in fact, you know, and we have a property in Garfield Heights where we have 8 buildings, low rise. We're going to be doing 8 large mural installations on those properties, on that property, just to give you an idea. So, you know, we do want to have a more progressive outlook.
Okay, thank you. Board, we need to address the city planning decision first, so.
Can somebody read the city planning ruling that Mr. Riccardi sent?
Yeah. Hold on a second. Let me bring it back up. It really doesn't say anything other than it's not approved. It just says a motion to disapprove the large Smartland graphic on the side, passed by all voting members present. It was, oh, wait a minute now, that's actually the local design review is what you sent me, Mr. Riccardi.
Madam Chair.
There's nothing in the Planning Commission approval other than that they disapproved it. And Shannon Leonard, as she stated, was actually in attendance at the meeting.
All right.
And I believe she stated that the Planning Commission determined that the sign was simply too large and they did not want to approve it.
Okay.
This was not, well, okay.
He said it was too big and not appropriate for residential, and it was not an art mural.
Well, I don't think that's what they said at planning.
Madam Chair,
Yes, Ms. Barnes?
I have a question. My question is, Madam Chair, did the sign go up before he got a permit?
Yes, that has been testified that yes, and he has backed that up and said they were not aware that they were supposed to get permits. So they did put the sign up before they got permits. And once they did that, that's what triggered them to get the design review and the city planning review, which they both got denied.
Okay, so this is not their first business, correct?
No, I don't think so.
Well, Madam Chair, just for the sake of the requests before us, arbitrary capricious, I mean, if the councilman wants to weigh in on this, be happy to
would
hear
like-
his testimony.
Okay. Can you hear me?
Yes, we can.
Okay. So I think we're making this more complicated than what it is. Let's step back a moment. Okay. They put the sign up without getting a permit initially. They have acknowledged that that misstep and that mistake and that oversight in their efforts to improve the building. As has been indicated, this was a building that was in sad shape, and they have invested substantial amount of money into it, and they put up a new sign in front. The sign is on the side of the building that they are requesting the variance for. I've received no complaints from the neighbors at all, none. They indicated, they have improved the outside of the building. They put a dog park in, et cetera, around this building. Here we are arguing about a sign on the side of this building, like it's the end of all, which is really starting to really tick me off. And I got derelict properties all around it that I can't get the city to do a damn thing about. I can't get the city to do a damn thing about. Abandoned buildings just to the west. 3 buildings abandoned to the west. Down that street, 142nd Street, abandoned buildings. To the east, another derelict building I can't get the city to do a damn thing about. And here we are, we're like over a sign on the side of the building. It's like the end of the world. I don't get it. He made a mistake. He's applied for a variance to correct that mistake. He knows that he cannot do anything like this in the future as it pertains to this structure in this building. But to the board members here, let there be some common sense and some sensibility set in here. I mean, the man and his business has substantially improved this building. And around him is derelict properties that the city won't do a damn thing about. So I'm losing my patience over this stuff. So I'm here to support the variance.
Thank you, Councilman. Board, we need to address the city planning, the city planning commission issue first.
Yeah, before we leave, Councilman, are you saying that you find the city planning commission to be arbitrary or capricious or unsubstantiated by the fact in their ruling?
Yes.
And the reason you give is because the property owner has improved his property.
Substantially.
Okay. Just want to make sure.
Okay, I need a motion on the administrative appeal.
Madam Chair, given the testimony, I cannot find the planning commission to be arbitrary or capricious in their ruling. And in terms of unsubstantiated by the facts, seems to be a situation where ignorance of the law is not something that's an inadequate defense. At the same time, I think I heard from the appellant that they would be willing to put an art mural on that property. They just didn't understand the rules. So my question is, if we do vote to find it not arbitrary or capricious, does this shut down any further requests for a variance on an art mural that could go on this building?
I think that's a Rick Riccardi question, but I don't think he would even need a variance for an art mural.
Okay. Mr. Riccardi, is that true?
There is a process where it would be judged independently.
Right.
So,
but it's
if
not
you're
a
saying
variance
this-
per se.
if
Right.
you're saying, would a ruling on this large graphic business identification sign, would the city planning or the BZA ruling on that sign preclude a ruling on an art mural or preempt it? The answer is no.
Okay. That's what I was interested in. I don't know that we have a request for a variance for an art mural embedded within our decision today.
We do not.
However, in
We do
terms
not.
of what would be a two-step process, I think finding the city planning commission not to be arbitrary or capricious, nor substantiated by the facts, does not preclude the owner of the building moving forward with a different concept. That concept is not fully iterated today and would need to go through its own process, but it does at least open that door for that goal. So given that, I would move that I can't find the city arbitrary or capricious.
Second.
Call the roll, Ms. Kukla.
Ms. Barnes,
Yes.
Mr. Donovan,
Yes.
Ms. Britt.
Yes.
So, Madam Chair, to Ms. Wagner, the entire case is actually denied in this instance, correct?
Well, that's, as you know from our staff discussion, that is not my opinion. My opinion is that the board needs to rule on the variance issues also, independent from the planning commission. I think Building and Housing may have a different opinion that denying the planning commission ruling precludes the board from considering the variances.
What are we looking to approve on the variance? Is this an identity sign? Is this a business billboard mural?
You're looking to approve an identity sign which is much larger than the code allows. It says here the code allows 20 square feet and this is 384 square feet. So the board is needs to determine if there is, whether it wishes to grant a variance for the size of the sign.
Okay. So the city planning, do they have a role in the process of approving the identity sign, separate from the art mural sign?
Well, Mr. Donovan, there's no submission for art mural today. They were looking for us to grant them a variance so they can keep this Smartland sign that's here currently. So if Ms. Wagner is telling us to now rule on the Smartland sign, then right now we have to rule on whether they can keep this up or not. And so I believe the art mural came in question to whether the appellant would be amenable to doing something different here, which was discussed previously. However, art mural is not in the write-up. The write-up right now is they are asking us for a variance for the Smartland sign that is currently there.
Yes, that's correct, ma'am.
We have Sharonda Watley and Rick Riccardi with their hands raised. I'm not sure if Rick was from before.
I'm sorry, no,
Or
it was my
Sharonda.
mistake. Excuse me, sorry, let me.
The examination for the variance for that sign is moot because the city planning ruling, the city planning approval that is required for that sign and which was denied has been appealed and upheld by this variance. So it's not possible to grant a permit for that sign when the city planning ruling, when the city planning approval that is required has not been granted, and this board has upheld that denial.
But that's not why I'm
So
here.
the second, the second inquiry of the ways in which it doesn't meet the zoning code, it is moot.
And this is the issue that we had to come up before, and so this needs to be worked out between, you know, building a housing and planning before it comes here, because I feel like we're getting, you know, advice in two different directions, and we're not really sure what the proper way to rule. And we did just uphold the City Planning Commission's denial. And so from the building and housing perspective, that means that this case is over. Our attorney, however, is saying that we should rule on the variances that were requested. So this is the issue we had before. And so I'm going to be a little annoyed as well that, you know, we can't properly figure this out because we can't get proper guidance in either direction.
And this is Councilman Polensek, if I may.
Sure.
This is so confusing. This is, I mean, when an appellant comes in to apply, why aren't they given the proper instructions and directions as to what to file for? And I mean, I'm seeing a reoccurring pattern here of misinformation, misdirection, and at the end of the day, it's like, you know, it's adversarial, it's confrontational. I mean, I don't get it here. If when an appellant comes in to request a variance, or is told by Building and Housing to request a variance, why aren't they given the proper instructions and track to go down? I don't get this anymore. There's nothing but confusion here. And so again, I want to go back to what was just stated a moment ago. They are applying for a variance for the sign on the side of the building that is there presently. They are applying for the variance. And I would ask the board respectfully to vote on that request and the variance for the sign.
Madam Chair, can I make a comment?
Yes, please, Ms. Wagner.
The sign code is not very clear in many cases as to its procedures or provisions. I understand what Mr. Riccardi is saying. However, I think it's ambiguous in the code whether or not the board can independently grant a variance if Planning Commission denies approval. And given that the legal standard would be to resolve ambiguities in favor of the property owner. That's the only reason I'm saying I think the board should rule on the variance.
Madam Chair, I just want to point out that what I put up on the screen is an email from Liz Kukla to the applicant on July 14th explaining exactly what was happening with the administrative appeal.
Okay, thank you. We've ruled on that though. So here is the quandary is, do we now move on and rule on this sign as is, or is this over because we upheld the City Planning Commission ruling? And I believe that the last time we did just move ahead and rule on the variances. So board members, what do you think?
Chair, Ms. Barnes, I am so confused.
Yeah, join the party. Mr. Donovan?
You know, I think in both instances, the argument was we have, you know, good business owner, people that have invested in the city of Cleveland, and we ought to just give them a pass to not have to follow the zoning codes as it regards to signage.
Kelly, can I make a statement?
Let Mr. Donovan finish and then you can.
I'm done.
Oh, okay. Go ahead, Shannon.
So generally in regards to the sign code, at least in the last 3 years, so the sign code gives planning for signs in the design review district, it gives planning commission the ability to vary. When you have something that is this large that requires this big of a variance, it's no longer minimum variation. So the actual city planning commission has to rule on it. So Director Collier doesn't have administrative approval in this case. So this case went to city planning commission, 1, to appeal design review, and 2, to seek the variances necessary for the size of this sign. And those variances in planning commission were denied. So then what happens next, generally, when we have these types of cases, is the applicant comes to you all to seek a reversal of planning commission's decision. And that in and of itself generally gives them the variances that they are seeking. So this is a new way. I've been on maternity leave now for almost 3 months. So I'm not sure if this is this is something new that the city is doing, but generally signs and design review districts give city planning commission the authority to grant variances when necessary from the zoning code. And generally those variances are given by planning commission when they approve the signage, and that directly correlates with the design review, so the design. So that's why I believe Mr. Riccardi is stating that if they denied if planning commission denied the sign, they also denied the variances. And then he comes to you all for an appeal of city planning commission's approval, and you all upheld city planning commission's decision. The next step, I believe, is if he still wants to hold on to this sign, then he would go to the court of housing court or court, whatever municipal court is across the street. And so that's how we had been dealing with signs in design review districts for the past at least 4 years since I've been with city planning, and handle signs exclusively.
Thank you, Shannon. And I understand that point. However, we're getting a counterpoint from our attorney saying that we should rule on the variances regardless of how we move on the city planning commission. So that's where we're having an issue.
I came here for zoning variance. I was told that this is where I come for it. This is where we have to ask for it. In regards to what happened at planning, you asked if it was fair or if things went off the rails. They did. Everything that we've discussed, there's nothing that was discussed during the planning meeting. In the planning meeting, it was a bashing, it was not an intellectual conversation as we're having today. And so, to say that what was said there, I'm not sure what was really said there. What I know is that I have seeked out over and over again, what is the next step? Where do we go with this? We're advised the next step is to zoning for a variance on the size of the signage. We're not asking for anybody just to look the other way or get a pass. In fact, Director Collier at planning testified that he also does believe that this was an error. As we've testified, this was an error. We're trying to correct that. We've taken all the necessary steps, done all the necessary meetings. We are good Samaritans of that property. We're good caretakers. There should be no reason why we cannot get a variance at this hearing today, as well as the chair.
Sir, we understand all of that, and we're not holding this against you per se, but we're just trying to figure out what the proper process should be right now. So we have your testimony. We understand your position. We understand the councilman's position. We made a vote on one decision, but the issue right now is not really with you. The issue is we're getting two different, advice on how to proceed. And
yes,
so that's where we are. So so I need my board to either say, we don't need to move further, that's it, or we need to rule on this variance. It seems like the rule of law so far has been that once we upheld the city planning decision, that's the end of the case.
Madam Chair, this is from Ms. Barnes. I am so confused, so I don't know how to rule on this. Because my person, I feel that if he went to the council person too should guide him in what way to go with this sign. And I understand the council person on how he feel, because I feel the same way today. I am really confused. I don't know how to vote on this. So I would move that maybe we dismiss this part.
Mr. Johnson?
Madam Chair, could I make a comment here?
Yes.
The councilman is absolutely right. Basic fairness requires that a person who's trying to do something is given clear direction from the city as to what ordinances are applicable, what the process is. And in this case, Shannon indicated that the Planning Commission denied this because they didn't think it was appropriate for them to approve a sign that was so much bigger than what the zoning code allows. And that's kind of within the purview of the BZA. I'm not saying you need to grant it or not. It's a very large variance, but I can't accept a position that says that the BZA can't rule on a variance. And I think it's unfair to the applicant, which I realize doesn't help the board at all because you're getting different information from different people.
Yeah, this is the same thing that happened previously, and so I mean,
last time we did
rule on it, but I'm gonna do that again this time. So I need one of my board members to make a motion about the actual sign. However, after this, I'm gonna implore Building and Housing and Planning or whoever else in this process to have this properly worked out so that we're not trying to figure out things during the actual hearing, because we've already spent too much time on this already because we are not getting proper direction here. So I'm going to ask.
This is Richard Riccardi, and I would just state that if the variance is granted, I would like Ms. Wagner to issue us an opinion on whether or not to allow the permit or not, because we will have two conflicting rulings. So as long as that's understood, that Ms. Wagner is going to have to tell us if the permit is approved or not, because you're going to have city planning denying it, which is a requirement, and BZA approving a variance for it. So, you know, it's fine whatever happens, but she is going to have to advise us on whether this means the permit can be issued or not if the variance is granted. Thank you.
The comment I need to make is that I don't have the ability to advise Building and Housing to issue an opinion to them. I'm not their attorney. I do understand the issue he's stating. It seems to me if the board denies the request for variance, then it's all taken care of. If the board grants the request for variance, then I think that's something that the city internally would need to determine whether a permit can be issued or not.
Yeah, that's fine. Just as long as
very confusing.
As long as it's someone from your department.
Yeah,
Ms.
it would
Wagner.
have to be
Thank
right.
you.
It would have to be your attorneys that would do that.
I know what Building and Housing sent us. This was their instruction to come here.
Yeah,
So-
sir. We
know.
We're not taking any more testimony right now. We're just, like I said, we're trying to figure out the process here. So
We know that there has been legislation passed, introduced by Kevin Kelly, that allows the city to actually challenge any rulings by the Board of Zoning Appeals. So if that's what Mr. Riccardi ultimately is getting to, then you're right. We could create a showdown between two City of Cleveland departments on ruling and which one would wins the day. Mr. Riccardi,
That's not what I'm saying at all. I'm just saying you're going to have two conflicting opinions, and we just need to know which one to follow. Thank you.
Okay. Maybe I didn't make myself clear. If we have two conflicting opinions, the city of Cleveland could challenge the Board of Zoning Appeals opinion if it so desires. True?
That is correct, Mr. Donovan.
Okay. So
Mr.
board
Donovan,
members, we
yeah, I
have to
think-
ask ourselves the question, if we don't think it's out of our jurisdiction, we make two conflicting opinions by our ruling.
or not. It depends on how if we don't
That's
approve it,
true.
if we don't approve this sign, all of this won't matter. So I guess.
Let's float it down the river. I'll make
Yep.
the motion. I'll
Thank you.
make the motion that we would approve the variance to allow the sign. Do I have a second? Okay, I didn't hear any. Second one, I'll make a motion that we would disapprove the sign request for variance. Do I have a second?
I'll second that. I don't
Yes.
know what Barnes is. Okay.
Yes.
Marlene said yes.
Okay. I guess
All right,
we
call-
have a motion, we have a second.
Call the roll, Ms. Kukla.
Liz,
Liz, are you there?
call the roll.
Oh, I'm sorry. I didn't realize I was muted. Ms. Barnes,
Yes.
Mr. Donovan,
No?
Ms. Britt.
Yes.
Calendar
Yes.
21-105 is denied. It'll be ratified next week and we will send you a letter.
Well, wait a minute. I don't think it was designed. I don't think we had a sufficient number of votes to make the ruling.
Mr. Donovan, a ruling requires 3 affirmative votes. Since there are not 3 affirmative votes to grant the variance, then it is essentially denied.
Denied or dismissed?
Denied.
Interesting. All right.
All right. Hopefully the appellant can work with city planning to come up with, something different. And please internally work these things out before they come to us, because I don't want to be trying to figure these things out we spent a half hour on this. So we'll move on to the next case.
Greatly disappointed. Greatly.
21-122 at 7321 Elton Avenue. VR Canez owner proposes to erect a 2-story single-family residence with a 1-story detached garage on a City of Cleveland land bank lot in a B1 2-family residential district. The owner appeals from relief from the strict application of the following sections of Cleveland codified ordinances as listed in the agenda and the public record. Donovan.
Sorry about that. Anyone that's going to testify for this case, kindly raise your right hand. Again, I'll make a statement looking for a response of I do, your name and address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Caitlin Cole with Canez, 7555 Bradle Drive.
Thank you. Anyone else? No City of Planning? Okay, hearing none, on to history.
Thank you, Mr. Donovan. There's been no change in the zoning since 1929. There are no variances on file for this address. And the most pertinent information I found in our records is that in 2008, a permit was issued to demolish a 2.5-story frame 2-dwelling unit. That's all that I have, Madam Chair.
Thank you. We're getting an awful feedback. Is everyone muted? Okay. Is that still feedback? Yep. Okay, legal standard, Ms. Wagner.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the maximum gross floor area requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. Who's gonna be, Maurice, quick summary, please.
Yeah, unlike the last case, this one is very straightforward, and it's just a floor area variance.
Great,
Something
thank you.
we grant all the time.
Yes. Okay, Ms. Cole, go ahead, present your case.
Hi, thank you guys. So we're proposing a 2,283 square foot home with a 2-car detached garage and a finished basement. So the lot size is 3,881 square feet. So according to the zoning code 355.04B, we cannot exceed 1,940.5 square feet. So we're requesting a variance for that 342.5 square feet. We do have a client for, I apologize. We do have a client for this home who's very eager and excited to get into the neighborhood. So I just wanted to note that as well.
Great, thank you. And the square foot exceedance is due to, is it our finished basement? Is that it, or?
Yeah, I believe it's the finished basement.
Okay. Yeah. All right, thank you.
Thank you.
City planning?
Yes, Madam Chair. This is a house that we have approved numerous times that Knez has built all over the city. We are in full support of this relatively minor variance.
Thank you. Board, any questions? If not, I'll take a motion.
I move that we approve the variance that's been offered at hand.
Thank you. Have a second?
So Donovan?
You might be muted.
Yes.
Thank you. Liz, call the roll.
Mr. Donovan?
Yes.
Ms. Barnes?
Yes.
Ms. Britt?
Yes.
Calendar 21-122 is granted, except for number 3, and it'll be ratified next week. We will send you a letter.
Thank you all for your time.
Thank you. Moving on. We'll save the invoice for last. We'll move on to 21-087 at 133 West 65th Street. Apartment 92 Gordon Square LLC. Owner proposes to construct a 3-story building consisting of 5 dwelling units and consolidate with existing non-conforming 4-dwelling unit in the B1 2-family residential district. The owner appeals from relief from the strict application of the following sections of the Cleveland Codified Ordinances as listed in the agenda and the public record. Mr. Donovan?
And everyone for this case is going to testify. Kindly raise your right hand. I'm going to read a statement, at the end of which I'm looking for a response of I do with your name and address. Do you swear that the testimony you're about to give is the whole truth and nothing but the truth?
I do. My name is David Parrish with RDL Architects, 16102 Chagrin Boulevard.
All righty. Next.
Bridget Kent Marquez with Northwest Neighborhood CDC, formerly Detroit Shoreway Community Development Organization. I'm the housing director, 1447 West 45th Street, Cleveland, Ohio, 44102.
Thank you. Anyone else?
I do. Nicole Marino, 1335 West 65th Street.
Okay.
John Schambach. John Schambach, 1339 West 64th, and I own 1335 West 65th.
Okay. Anyone
Mike
else?
App. Mike App. I'm the property owner. I also live at 5804 Herman Avenue, Cleveland, Ohio 44102.
All right. Anyone else?
John Birdsell. I own the property at 1340 and 1344 West 65th Street.
Thank you. Anyone else? Last call.
Yes,
believe-
I
yes,
apologize. Hello. Yes, I'm sorry. My name is Zvonimir Mirchita. Call me Alex. It's easier. I'm at 1329 West 65th Street, adjacent to the current property.
Thank you. Again, last call.
Good morning.
We have
Jason Martinsik, property owner, 5855 Father Caruso.
Okay. Anyone else?
Joshua Perkins, property owner, 5802 Herman Avenue.
Thank you. Anyone else? Last
I believe
call.
Adam Davenport is also going to be commenting. I don't know if he's looks like he's muted.
Thank you. Last call.
Adam?
We got Adam.
Oh, you got Adam?
Okay.
Okay.
I think we got everybody. On the history.
Thank you, Mr. Donovan. This property was originally zoned general retail in 1929. In 1978, it was changed to the current two-family district, and the Building and Housing Administrative Records Office in 1925, a permit was issued to erect a two-story apartment building and a one-story garage. There are no variances on file. And in the more recent history in our Acela system, I found a violation notice was issued in 2011 to the property for unauthorized use as illegal auto repair. And in 2015, a permit was issued to install 3 new windows. And I believe that's all that I have, Madam Chair. That's relevant.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and area variances from the front yard setback, rear yard, off-street parking, maximum gross floor area, and minimum lot size requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship, particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Maurice, summary, please. What happened to Maurice?
Forgot about that. As you know, this had to be re-advertised because the applicants changed their design to respond to neighborhood input. We're looking at, as Lori said, a use variance. This is not permitted in a two-family district, and a floor area variance as well.
Great, thank you. So who's going to be spokesperson for the project?
David Parrish from RDL Architects.
David? Did you
Yes,
say
ma'am.
David? Okay.
Yes, ma'am.
Okay, go ahead, proceed, David.
Okay, like was just mentioned, first off, I'm representing Michael Apt of Apt 92 Development. He's the current owner of the property. And we've as was mentioned before, we held 2 community meetings where many residents turned out and gave us a lot of their thoughts. We have incorporated many of their comments into the design of the project, which is why it has been resubmitted recently. I guess we're looking at in the interest of time, I know we put together a full presentation here, but you all have seen a lot of things so far today. Could you scroll down to the site plan of the property?
Yeah, if you can just keep it to the variance list, that'll be good.
Yes. No, that's the end. Please go back. It's called Project Info. It's about in the middle of the deck. Getting closer. Okay. Well, I'm not seeing the image, but anyway, I'll just verbally describe it. The existing apartment building is four apartments, and there is a garage in the back. We propose to demolish the garage, and there's an empty lot. Oh, okay. Oh, go back one. There, perfect. Okay, you see to the north is the existing apartment building, and we were proposing a new apartment to the south. There will be it'll be 5 units. The first unit will be just on the ground floor only, and then 4 apartments above. Well, one of the comments we had previously was that we did not have enough parking. So the code requires 1 space per unit. We're proposing a total of 9 units, and we're proposing 11 parking spaces. So we listened to that comment. The back of the proposed building will be two parking spaces under roof, and then the remaining 9 will be open air. I'd like to bring to your attention the site data. We have a couple of typos. All right. Okay, good. We have a couple of typos. I just wanted to bring them to your attention. Under minimum lot size, it says 6,000 square feet. That actually is 21,600. And we are looking for a variance for 9,065.
Yeah, the write-up has it. The write-up has it correctly. So
yes, I just wanted you to know that there's a typo in there. And the front setback, the requirement is 10 feet. We are missing a 1 there. We're actually 15 feet back from the setback. And then under the parking spaces, we're providing a total of 11 spaces. The last thing I'd like to bring to your attention is the very last slide. I can get into more detail with a lot of the other things, but in the interest of your time, I wanted to just. Is that the
slide?
No, keep going. It's the one of the overall area.
Okay, hold on. I'll keep going. Just tell me when to stop.
Yeah, this is our design.
That was the last slide that I have for the presentation.
You had it up there before.
Maybe it was before. Hold on, let me scroll back.
There it is. Whoa. Now go up. You almost had it.
This one?
No.
That one?
It was a color-coded overall plan. Not this one. The next one, just directly after it. That's it.
That one?
Okay. Yes.
Okay.
And what I listed here is the two variance items we're proposing, and we just did a little research of other properties in the neighborhood and listed where you see the areas indicated in red. Those are properties that currently don't meet the zoning code either, and they're open for business. So I just wanted you to be aware of that. Our property is indicated. It is number 2. So you can see item 3 and 5 are essentially across the street from us. Item 8 is down the street from us, and then there's Stone Mad number 9 is sort of diagonal to us. And then there's other properties to the south, property 1, property 6, 4, and 7 that we identified. Those are also part of our analysis. Those do not meet the code either.
Okay, Mr. Davenport, like to hear from you, please.
I had to jump away, so I do need to be sworn in. Sorry about that.
All right, raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Thanks, Madam Chair and Board. So this project has gone under many revisions in the past few months, and this is, I think, that this latest plan before you shows an equal number of parking spaces to the units, which is the major change from the past iterations. We've been generally supportive of the plan as infill apartment housing. We don't see too many small apartment buildings like this through design review, but it's a smart project infilling a vacant lot. A number of other projects on 65th, if you're not familiar with the area, have gotten a couple of variances from this board the past couple of years. A small gym across the street for parking and use, and then up at the corner of Herman at 65th, Il Rione also received a parking variance for their patio, I think, in the last couple of years. I'll keep it short because this meeting's been dragging on. We're supportive of the variances requested for the floor area, I think, and I think I'll scan my sheet, but I think it's maybe the other rear yard as well.
No rear yard.
It's
no rear yard.
Oh, no rear yard. Okay.
It's just the floor area
it's just
ratio
use
and
and
the
floor
area.
area.
Oh, okay.
Yeah.
Yeah. Oh, okay. Sorry. This one was just I'm getting these mixed up now. Yeah, just floor area and use. Smart. I think it's a smart infill housing project. Something that could be very useful to people who wanted to live in a pretty dense commercial district area and access transit very easily. Now that the RTA has improved the 26 line on Detroit Avenue. Thank you.
Thank you, Adam. I'm gonna go to Bridget now at the CDC.
Yes, thank you. Good morning. We do understand that leading up to this, there has been some contentious nature of the project, but in its current form, we have no objections. In short, we're not opposed to the requested variances.
Thank you.
Thank you.
I'll move to the residents now. I'll start with Nicole.
And just so everyone is aware, I'm actually speaking on behalf of the 3 other tenants that do live on 1335 West 65th. Unfortunately, they're not able to join, but all 4 of us as tenants really strongly disagree with the project. Being immediate neighbors.
Bridget, one thing I need to announce before I start hearing from the from the neighbors. You have to keep your comments to the actual variance requested. So the use variance and this floor area ratio variance, those were your comments are most needed on those 2. So go ahead. I'm sorry, Bridget, continue.
Bridget, I'm sorry, did you need to finish? Go ahead.
Yeah, no, go ahead, continue now.
This is Nicole. I'm Bridget.
Sorry.
Oh,
Nicole, I'm sorry. I got mixed up. No, go ahead, Nicole, finish.
Okay, no problem. Well, then just to kind of remain with the variance, I mean, just the kind of fear of the immediate proximity to the house. And then aside from the design that it doesn't necessarily fit with the street, we'd much rather see a single or 2-family home, which is what is called for on West 65th Street.
Great, thank you, Nicole. I'm going to move to John now.
Yeah, I'm the owner of 1335. I pretty much support my tenants. I think actually, I disagree on one thing. I think it's a great design. I think it's just on the wrong street. A lot of properties have been built in the past 10, 15 years, mostly 1 and 2 family. There have been some, most of the exceptions that were pointed out were from a long time ago, buildings that were constructed in the 1910s or 20s. So it's, I'm not against progress. I congratulate Michael for buying the property, and I wish him well. I just wish I had a 2-family next door instead of something bigger.
Great, thank you, John. I'm gonna move to another John on West 65th. We had 2 Johns, right?
Yes, figures, one of those names, John Birdsell here. So I think, when you look at the building, is it aesthetically appealing? And the answer is yes, absolutely. It's a beautiful building. I think when you look at other buildings in the area, you really have to look at the history. And I don't really think it's reasonable to hold those buildings to zoning codes that we have now. Previously in the past, there have been fires, there have been issues, the Chicago fire, and a lot of those things happened because there were no real zoning codes. We now have these zoning codes, and they're really geared towards the safety of the residents of Cleveland. So I think it's really important that we adhere to those codes. The area itself has literally quadrupled in population density in 10 years, and the support, police, fire, EMS, really hasn't been increased in that area that I'm aware of. In fact, I even had a conversation with the city of Cleveland, the fire chief, and he also agreed that yes, the population density has definitely gotten larger, and it's making his job more challenging. I'm very happy that Mr. App is what he's building is not really appropriate. There's one neighbor, Carl and Dale, Carla, Jenny Spencer, in reference to this, they had a family emergency, and they actually emailed their disapproval of this. And I'd like to make sure that whoever's representing Jenny Spencer, that they put those emails into evidence, because they're adamantly against it. I could read the highlight is, it's just too big for the space. It's not appropriate. We're happy about the development of the neighborhood. In fact, they built a beautiful single-family home, a green home, which is actually used in the city of Cleveland's recommendations now. So they went through this zoning process and all the codes. So for the record, Carla and Dale were against this. Also, Eddie Martinez, who is actually right next to John Schambach's property, he's adamantly against this too. But unfortunately, it's difficult for people to make it to these meetings because of, we have work to do. Heather across the street, she recently built a home, and she built it according to the current zoning codes, and her home is a model home. It's absolutely beautiful. So I'm really happy that Mr. App is doing this, but I think what he's doing is not really appropriate. And that's basically the long and short of it. If you look at his website, he specifically says about, he brings up about
John, we want to keep
Yes.
it. We want to keep it to the variances here. So please keep your comments to the 2 variances.
So, okay, so the square footage variance is where I have the biggest issue. 3 stories is not size appropriate for the area. Every building there is 1 or 2 stories. Even Stone Mat, Il Rione, there's no 3-story building on that street. As far as aesthetics, it's a beautiful building, but it just doesn't belong on West 65th. If you drive down West 65th, this will stick out like a sore thumb. So that's really my issue. It's not really size appropriate. It's not design appropriate. I applaud Mr. App. Fine, build a single family home, build a duplex, or he owns that other brick home right next to it. Mirror that on a smaller scale. Then I'd be fine with it. But what he's doing now is really unsafe, and I think you just have to, I get it. He's a developer. He's got a number of properties, but you have to choose people over profits. And I'm hoping the BZA chooses people in this case, that they build something appropriate there, and not what he's currently proposing. And again, Heather, Eddie, Dale, Carla, they couldn't be here, but they're also all against this.
Okay, thank you. And we're going to move on to Alex now. Alex,
Can you hear me?
Say?
Yeah.
Yes, can now.
Can you hear? Yes. Okay. Thank you. Yes, I live adjacent to the current property, and I've been here since 1989. And when Mr. Apt purchased the building, I was a little bit apprehensive. Needless to say, the previous owner was very difficult to live here. But since the exchange of the properties, I have to say that it has been much easier to live with. So for me, it is really much more of how the property is managed. I don't object to any of the variances. I think, pardon the pun, a little variance is good for the neighborhood. Um,
I'm going to use that.
I think, you know, things are not static. Cities go through an evolution, whatever the needs are. And currently, you know, there is need for this type of housing. But mostly, I did have some issues with the parking, which I see has been actually modified. I'm very happy, you know, with that. So all in all, I'm very happy to have Mr. Apt as a neighbor. And as I said, it's been easy living. I don't have any objections to the variances.
Great, thank you, Alex. I'm going to
Thank
move
you.
on to Jason.
Apologize for the delay. I had to unmute. I am also in 100% agreement with the last gentleman. I am 100% all for this development. I drive down West 65th several times a day, and I would much rather see a new dwelling that is 3 stories compared to some of the other dilapidated buildings in the surrounding area. And I feel if this is denied for Michael, an App 92 development, that it is setting a double standard, that he is not able to build and improve the development, which I also made a $500,000 investment in, but other tenants, other building owners get a pass and just leaving their buildings in just unacceptable condition for the amount of area and investments people are making in this new neighborhood.
Thank you, Jason. We're going to move on to Joshua now.
Yes, I would just say as a resident of the neighborhood, I think continued improvement and development, especially into a modern aesthetic commercial space is more than welcome. And we need to continue to improve our upswing in property values. It's very supportive of the design submitted and variances being evaluated, and supportive of Apt's continued development in the area. Looking for any opportunity, frankly, to continue to improve the West 65th Street area, and not necessarily simply by placing additional single-family homes, as I don't think that's a continued trajectory that supports the long-term needs of the West 65th Street area.
Thank you, Joshua. We've heard from all the residents. Mr. Apt, did you have something you wanted to say before? Or if your architect has anything else they want to say?
Yes, ma'am. I just wanted to say I live a block away from this property. It means a lot to me. This is something that we're really looking forward to match the neighborhood in. On the size variances, we listened to a lot of input from the community, and we really wanted to make sure that we were matching with the consistent build that was in the neighborhood now. And so that's what we, after I think 3 iterations, I've spent a lot of time and money to let not only my neighbors, but the people that are going to be interacting with this property, like you've heard several people say, have something that fits into that neighborhood as it is. Thank you.
Thank you. Board, any questions, concerns?
Madam Chair, this is Liz.
Yes, Liz.
Just a point of clarification, there is no height variance requested in this case.
Correct, there is not.
Can somebody review the facts and figures, if you will, on the variances sought at this point?
What do you mean review the facts and figures?
Well, I mean, there's certain requirements that the project is unable to fulfill. That's what they're asking the variance for. But I know things like parking probably used to be an issue, but is no longer.
Correct.
Yes, they met the parking issue. The variances they're asking for today is the use variance in a two-family and the gross floor area because it's a multifamily building and a two-family. So of course it's going to violate the gross floor area. So those are the
Okay.
only two variances today.
Those are the two.
Yes.
And somebody testified there was maybe one or more public meetings. What was the overall response in those settings for this project?
John Birdsell. Actually, the overall response from the people at the meeting was against it. We did bring up the issue of parking, and that's why he changed that. But I myself personally was against, again, the size. Everyone at the meeting, and I actually have the one meeting, I have it all on video, was saying, we're happy about a two-family, we're happy about a one-family, we don't want this. So it was not a positive response. The last meeting, actually, Mr. Apt brought someone there that several of the people there felt intimidated and didn't even want to talk. And they actually did contact Jenny Spencer by email and let them know how they felt after that meeting.
Mr. Chairman or Ms. Chair.
Yeah,
Ms.
I was
Cow-
going to say, Bridget, did you want to chime
Yes,
in on
yes,
that
I
at
can
all?
just add, I was at the second meeting. I was not at the original community meeting. At the second meeting, I think responses were very similar to what we're hearing today, where they are mixed. As far as specific to the two variances being requested, I did not hear any substantial specific feedback to those variances. And yes, Councilmember Spencer was reported to after those, both of those meetings as well.
Thank you, Bridget.
We have
Madam
Mr.
Chair.
Apt with.
Madam
We
Chair,
have
this
the
is
applicant,
Liz.
please.
Sorry, Mr. Rulins. If I could give the particulars of the first time this was on the agenda. I'm not sure if Mr. Rulins was going to do this, but originally it was the proposal was to construct a 3-story building consisting of 5 dwelling units, office and gym space, and to consolidate lot with existing non-conforming 4-dwelling unit. At that time, the use, of course, as an office and gym space and multifamily is not permitted. They were requesting a 10-foot front setback along West 65th Street. Oh, I'm sorry, they were proposing 5, where 10 feet were required. The variance required at that time was a rear yard equal to the height of the building of 30 feet, and they were proposing 8. And also the accessory off-street parking issue was there, and now those 3 items are gone. And they're no longer asking for those items as well as the office and gym space. They've been omitted. And also the maximum gross floor area, and I'm thinking this is also what Mr. Donovan wanted to get to. A maximum gross floor area originally proposed was 12,408, where 4,532 were permitted. Now with the updates, the appellant is requesting 7,938 square feet. And so the requirement for this type of development would have been a lot size of 21,600 square feet. And the lot size in question is 9,065 square feet. I think I covered it all, Madam Chair.
Madam Chair, the applicant would like to speak.
The applicant? Okay.
I just want to make a comment that during those community meetings, we listened very carefully to all the comments. And when we came back, we redesigned the building. I mean, we could not accommodate everyone's comments, but I think we accommodated most of them. The only other comment was in regard to the character of the neighborhood. I mean, I've been working in this business most of my life, and West 65th is a very eclectic. The architecture is very eclectic. There's a wide range of traditional and modern and different shapes. So there's really not one style in any way, shape, or form. So you really can't say that, oh, it has to fit in. It's already a very eclectic mix. Just wanted to make that comment. Thank you.
which I think is clearly shown on this aerial.
Yeah. All right, thank
And
you.
also,
I'm sorry. Is
that's
that
okay. I just also kind of wanted to make a comment about that's also very sad that someone's calling all these houses kind of like dilapidated. I'm not really sure where that comment came from. And it's not necessarily this, I'll completely agree about how there's a lot of changes within there. It's more so just kind of the size and why like expensive one bedrooms might not necessarily fit in kind of this community neighborhood. And that, again, whoever's kind of calling buildings, you know, dilapidated, why those specific single family or two family homes, more money should kind of be put into like our neighborhood and the community rather than kind of putting up something that might be, you know, furthering out people that want to currently live here, including all of our tenants.
great? Thank you. That's why I always want people just to speak on variances and not personal opinions. So thank you. Board, if you have any more questions, if not, I'll entertain a motion.
Madam Chair, given the testimony here and recognizing there is some opposition to the plan itself, the density, etc., but at the same time, understanding that the appellant did interact with the community, did reflect some of those concerns to the best of his ability, I believe, that alleviated the need for on-street parking, etc. And given the support it does have, I would move that we would grant the variances requested.
Thank you. Can I have a second, please?
Second.
We have a second. Ms. Kukla, call the roll.
Thank you. Ms. Barnes?
Yes.
Mr. Donovan?
Yes.
Ms. Britt?
Yes.
Calendar 21-087 is granted. It'll be ratified next week and we will send you a letter.
Thank you, everyone.
Thank you, guys.
All right, last case.
Thank you.
Calendar 21-89, 81825 West 52nd, Public Works invoice. Stephen Warner, owner, appeals under authority of Section 76-6B, the Charter of City of Cleveland, and Section 32902D of the Cleveland Codified Ordinances from a decision of the hearing officer dated April 19th, 2021, to uphold the City of Cleveland's Department of Public Works to issue the invoice regarding abating nuisance, this is grass cutting, at the subject property. It was dismissed on June 28th due to unexplained absence of the appellant and reinstated due to a scheduling mix-up. Mr. Donovan?
Everyone who's going to give testimony to this case, kindly raise your right hand. I'm going to read a statement. I need a response of I do with your name and address. Here we go. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Stephen Warner, 17500 Shelburne Road, Cleveland Heights, Ohio, 44118.
Thank you.
I do. Natasha Brewster, manager of the protest department.
Thank you. Anyone else? Last call. Onward to legal standard.
Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. Mr. Warner, go ahead.
Okay. Okay, so we purchased this property in order to, it was an eyesore in the neighborhood, in order to tear it down, build a lovely house, which we have almost completed, as you see on your screen. We were cited for this. The citation was marked June 25th of 19. We didn't even receive this citation until the very end of July, and it was not even postmarked till the end of July. We paid it immediately and then received an invoice for cutting the grass. From that point on, we maintained the property. We cut it regularly. Every 2 weeks, we had a landscaper cut it right away. And then my son, who lives on West 47th, cut it at least every 2 weeks after that. And then we had another invoice that it was cut again on August 19th, which was completely unnecessary because it was cut not long before that. So, the protest is, first of all, I think the fees are overly punitive, especially since we already paid a citation and didn't even, receive it until after the grass was cut. And then it was cut yet again. And I'm positive it did not need to be cut the second time. And we did see Miss Brewster. I did have a hearing with her and was told to told to have my son send a letter attesting to the fact that he was cutting the grass and continued to maintain it to this day, which we are, and which he did. And I guess the letter arrived. I could swear that Miss Brewster never told me, at least if she did, I didn't hear it, that the letter had to be there by the end of that week. And it came shortly thereafter, and she said it was too late, and my protest was denied.
Ms. Brewster.
Okay, I had, our original hearing date was April 14th at 10 a.m. And when Mr. Wagner came in for the hearing, he didn't bring any additional proof. I send out the hearing forms 30 days in advance just in case anyone needs any extra time to gather the information. At that day, he did not bring, on the 14th, he did not bring any information. I gave him until that Friday to bring down the support and documentation of who maintains that property, and he did not bring it. And that's when I sent out the hearing form for our first hearing, which was on the 28th. And it was postponed so he can send me the information again, which I never received it. And now we're here today.
I'm sorry, what was that about the 28th of what?
The 28th, the June 28th was our second hearing with BOZA.
Right.
That was explained to you that it couldn't go through. You still had time to send me in that appropriate documentation that I asked of you the first and the second time, and I never received it as of today.
Oh, you never received that letter from my son, but I talked to you on the phone.
Yes,
and
me and
said,
you had spoken. I explained to you that I did not receive any information. I have to keep all information and stamped soon as when it's come in the building.
Oh, Ms. Brewster, you told me at the time that you received it, but it was too late, that it had to be in by that Friday. You told me you had received the letter, but it had come in too late.
No, I don't have any paperwork from your son. The only thing I have is the hearing form and the notes that I told you when I gave you to the 14th.
Okay, I don't know how that happened. We spoke on the phone and you had told me that you received it, but you had told me it had to be in by that Friday. So
I told you that it had to be in by that Friday at the date of the hearing, which was the
whichever
14th.
Okay.
She said.
Okay.
He said,
Yeah.
she said, there we go.
So, Ms. Brewster, is there still a window for him to provide proof of that this was cut?
I mean, that's totally up to y'all. After me, y'all have to make the decision if he can still turn it in.
I would be happy to resend that letter.
I
Why
have
don't
no
we do
problem
it?
with taking the letter.
Get it off our books. Get it
Okay.
off your books. Obviously, there's been a significant investment made here.
That's for sure. In this house, yeah.
Would that work then, Ms. Brewster? He sends a letter in that somehow got lost in the mail,
Yes,
and we can close this off and no more payments needed, etc.
correct.
Sir, would you like to withdraw your case here so you could just get this done between you two?
So I send it to Miss Brewster, correct?
Yes.
I'm sorry?
Okay, I send the letter to Miss Brewster.
Yeah,
Yes.
send your sons a letter. Yeah,
Okay, it'll come by email this afternoon.
beautiful.
No, it comes via mail or fax.
Okay,
Okay. Well,
send it by mail.
maybe that's the problem. It was
In
emailed.
fact, I would send it by mail and have them sign
And
for it.
fax. Yeah, I would do both, mail and fax, just to cover your bases there.
I agree.
Can I have a fax number? Hang on.
You guys can talk about this afterwards if you would care to ask us to dismiss your case.
Okay, if you would dismiss it
You
for
can
me and I
withdraw.
can call Ms. Brewster and ask for a fax number, that's fine.
Yep.
Okay,
Board, without objection,
Without objection.
I'll make the motion.
There we go. We need a motion.
I would move that we would accept the dismissal of the case without objection.
Without objection.
Without objection.
Thanks for spending your day with us.
thank you guys so much too.
I would like to say that, city planning worked very closely with Mr. Warner, and this project turned out absolutely fabulous. You did a really, really nice job on this house. Thank you.
Thank you so much, Adam. Appreciate that. Love you to come by and take a look at the inside.
We would love to do
All
that.
right, go have your love fest somewhere else.
Okay, no love fest. Thank you guys.
I believe we're done. Okay.
All right. Oh, we got old business, right?
Yes.
All right. Old business 1 through 4 without objection.
Without objection.
All right. And we have no affirmations or reinstatements. All right. BZA is adjourned.
Thank God.
Thank you.
You took the words right out of my mouth, Tim.
Yes.
I gotta